All right, ladies and gentlemen, it's my understanding from the bailiff that the jurors have indicated they've reached a verdict in this case, so I'll have the bailiff bring the jurors back out, please. All right, ladies and gentlemen of the jury, the bailiffs have indicated that you all have indicated that you've reached a unanimous verdict in this case. Let me ask your foreperson to stand, please. Yes, sir. Juror number 10. This yes or no question, sir. Is it correct that I'm sorry, juror number 9. Thank you. Is it correct, juror number 9, that the jury has reached a unanimous verdict with respect to this case?
Yes.
And have you signed and dated the verdict form? All right, if you would hand the entire verdict packet to the bailiff, sir. Thank you. You may have a seat, sir. Madam Clerk, would you announce the verdict?
Yes, sir. Ladies and gentlemen of the jury, your foreperson has returned a verdict in file number 13 CRS 211979, the state of North Carolina versus Travion Smith. We, the jury, by unanimous verdict, find the defendant, Travion Smith, to be guilty of first-degree murder of Melissa Huggins-Jones. Answer, yes. On the basis of malice, premeditation, and deliberation. Answer, yes. Under the first-degree felony murder rule. Answer, yes. This the 16th day of February 2016. Is this your verdict? So say you all.
Yes.
Thank you.
Ladies and gentlemen of the jury, if you would, just by a show of hands, indicate whether this is in fact your verdict, and with respect to both questions, the answers that the clerk has read are correct. Just raise your hand if that is true. Let the record reflect 12 jurors have raised their hand. Counsel, is there anything further that we require of the jury with respect to this first phase of this trial?
Not as to this phase.
All right, very good. So members of the jury, as you know, based on your verdict, we will move to a second phase of this trial. What I'm going to do, however, is release you for the remainder of the day and ask you to return at 9:30 tomorrow morning, and we'll resume with that phase at that time. All of the rules I've been instructing you on continue to apply. Don't talk about this case among yourselves or with anyone else. Don't form or express any opinions about the outcome. No media or independent investigation into these matters, and no conversation or communications with any parties, witnesses, or lawyers. We thank you very much for your service thus far. We look forward to seeing you tomorrow morning at 9:30 if you would gather in the deliberation room at that time. I'm going to notify the alternate jurors, and they'll be joining you as well at that time, so you should expect to see them. If you will, your notebooks are still back in the back. Let me ask you to do this. If you would just get your notebooks and hand those to the bailiff before you leave, so that we'll go ahead and keep those in our control over the evening and get them back to you in the morning. So thank you very much, ladies and gentlemen, if you'll follow the bailiff out the door. All right, ladies and gentlemen, so we have the verdict of the jury with respect to the first phase of this trial, so we'll move on tomorrow morning then with the second phase. I had mentioned to you the possibility of presenting the Edmonds-Tyson issue to the jury in a trifurcated proceeding, have the jury consider that issue, and then once that is completed, we would move forward then with evidence on mitigation and aggravation, depending, of course, on the answer to that second, to that question. The law is not specific as to how this process goes. It could certainly be consolidated into a single second phase of this trial, but I think there's enough latitude to present the issue in a trifurcated proceeding as well. Does the defense wish to be heard with respect to that?
We believe the trifurcated proceeding would be appropriate. And I guess I'm not sure of the state's position, and so I could elaborate more once I understand the state's position.
Let me ask you, would there be an intention to offer any further evidence before we got to that question?
I don't believe so. I would like to consult briefly with Ms. D about that, but I think we don't.
I had not envisioned us putting on any additional evidence if that was going to be given as a single question before we proceeded to the sentencing phase.
All right. Let me hear from the state.
As I mentioned over the weekend, I think I'm sure our position is that it should be just a bifurcated situation, that would be, as the instructions suggest, that it's yet another question that they have to answer. Otherwise, I don't know how you would do it other than we just stand up and argue to the jury in terms of if no one's putting on evidence. And so that being said, I think that the instructions tend to suggest it's appropriate to do in a sentencing phase and have them answer that question first. And so we would ask Your Honor to go in line with the instructions phase and ask that it be just a two-part phase, that is the guilt, innocence, and the sentencing. Yeah, and again, you know, we've certainly been in a position to consent to Your Honor expanding the Edmund-Tyson issue, but they have clearly come back on premeditation deliberation as well as the felony murder rule. So I think in that regard, we also should move forward to the sentencing phase in general and then are prepared to argue that specific issue to the jury at the appropriate time.
All right. Yes, sir. Go ahead.
I mean, I do recognize that there has been a conviction on both. It is, but they were given instructions that would not indicate a variance away from the Tyson-Edmonds issue as it would be pre the change of the law that we had talked about earlier, where they would have had to make specific findings of either this defendant having specific premeditation or this defendant doing certain acts. The only thing that they would have necessarily concluded by this was that he was involved in a burglary and that the co-defendant or the accomplice would have acted with premeditation deliberation. This could have been their finding, but we just do not know based on their findings in it.